Mainness, item number 1.
May it please your lordships.
Yes.
Lordships, this is a matter, lordships, that is pending before the learned CGM, my lord.
Yes. Yes.
And lordships, in this matter, lordships, the next date is on the next date, lordships, evidence of the complainant witnesses will be adduced before the learned lordships, learned court of CGM, my lord. Now, lordships, most respectfully submitting, my lord, lordships will come to page 16.
Yes.
Lordships will see that this is a complaint application, my lord, which has been instituted, lordships. The accused person number 6, my lord, Gajal Misra, sees before my lords through this criminal petition, my lord.
Yes. Okay.
Now, lordships, this criminal petition, lordships, have been instituted, lordships, without resorting to, lordships, in my most respectful submission, section 154(1) and section 154(3) of the CRPC, my lord. Now, lordships, what has happened is, lordships, before my lord, before instituting a police complaint, this complaint application has been filed.
What is it? Why is it a prerequisite? There has to be a police complaint before CM.
Lordships, in a cognizable offenses which are cognizable in nature, lordships, there has to be a police complaint first. It is only after a police complaint has been filed, it has been duly investigated by the police authorities, lordships. If the police authorities submit a final report, is there
any bar in filing CRPC in respect of cognizable offence?
Lordships, there is a bar, lordships. Under section 154, lordships.
Yes.
Read with section 150, section 154 of the CRPC, subsection 1, lordships.
Yes.
Read with section 154, subsection 3, my lord. These provisions under subsection 1 and subsection 3, lordships, have to be exhausted before filing a complaint application, my lord. And lordship, since in this case
where
there
it
is
is
no
provided,
police complaint,
you were referring
lordships,
to.
May I take your lordships? In this matter, lordships, in my most respectful submission, there is a judgment of the Honorable Supreme Court, my lord,
yes,
which settles the issue, lordships. I have mailed that judgment to the learned in the website of the court, lordships. Today morning, I was asked by the learned lordships, the court master, lordships, to do that, lordships. That is 2015 6 SCC 287, my lord.
Has he given 2000? He's referring to some book. It is not before the court.
Lordships, this is the judgment, lordships, 2015 6 SCC 287, my lord.
(2015 6 SCC).
My lord, 287, my lord.
Yes. Just ask for that book.
Now, lordships, before your lordships takes up this, my lord, if I may be pleased to, lordships, just highlight the lordships, some of the orders that have been passed, lordships, by the learned CGM, my lord. Lordships may be pleased to come to page number 38, my lord.
Yes.
Lordships, may please to read, lordships, paragraph 10.
Yes.
Lordships, permission, Lordships, I am reading it, my lord. Peruse the FIR dated such and such. It is seen that the subject matter of the FIR is the same with the instant complaint, where informant Srimati Uma Devi Chokhani alleged that the accused number one, Silpi Chokhani, who is her daughter-in-law, left the matrimonial home on such and such date and was found to have been taken away various valuable properties from their house, and it is believed that she was transferring their valuable properties over a long period of time since her entry into their house as their daughter-in-law, and they have apprehended that various other people from Jaipur and other places are also involved in criminal conspiracy along with her daughter-in-law. Now, Lordships, a police complaint was lodged by the mother of the complainant, my lord. Now, Lordships, we turn to Lordships next page, my lord.
Yes.
It is admitted by the complainant and his mother that an FIR was filed where complaint as discussed above, that is his mother Srimati so-and-so, filed an FIR on 8/9/2018. Since no action or investigation has been carried out by the police against his wife, her relatives and her friends, he filed the instant complaint. Srimati Uma Devi Chokhani also stated that an FIR was filed on such and such date, but till date no investigation was carried out and her statement was not recorded by the police. Now, Lordships, may we please to turn to Lordships the next page, my lord, that is page 40, my lord.
Yes.
Lordships, may I read from paragraph 4, my lord?
Yes, yes.
Lordships, in this matter, a report was called from the OC Sadar, Lordships, Shillong, and he filed a report on the basis of which this finding is there of the learned court, my lord. The OC Sadar PS filed his report on 27/9/2021, stating therein that on 8/9/2018, Sri Ankur Chokhani appeared at the PS and submitted a complaint signed by his mother, Srimati Uma Devi Chokhani. At the time of submitting the complaint, Sri Ankur Chokhani requested that no legal police action be taken at the moment for reason that a civil case is being initiated in the competent court for recovery for legal custody of his daughter, and that further evidence is being ascertained from the family with regard to the theft of the property from their house. Based on the request of Sri Ankur Chokhani, the complaint was not registered and entry made in the general diary for further reference. Now, Lordships, it is evidently clear, my lord, though they have filed a police complaint, my lord, at the same time they have made an application not to proceed with the police complaint. Therefore, Your Honor, the police authorities, in my most respectful submission, did not register any FIR, and that complaint remained in the case diary without there being any investigation.
Yes.
Now, Lordships, if I may read the provision 154, my lord, for a second, Lord. Every information relating to the commission of a cognizable offence, if given orally to an officer in charge of a police station, shall be reduced to writing by him under his direction and be read over to the informant. And every such information, whether given in any writing or reduced to writing as aforesaid, shall be signed by the person giving it, and the substance thereof shall be entered in a book to be kept by such officer in such form as the state government may prescribe in this behalf. Now, Lordships, I am skipping the unnecessary portion, my lord, and coming to subsection 3, my lord.
Yes.
Any person aggrieved by a refusal on the part of the officer in charge of a police station to record the information referred to in subsection 1 may send the substance of such information in writing and by post to the superintendent of police concerned, who, if satisfied that such information discloses the commission of a cognizable offence, shall either investigate the case himself or direct an investigation to be made by a police officer subordinate to him in the manner provided by this code, and such officer shall have all the powers of officer in charge of police station in relating in relation to that offence.
Yes.
Therefore, Lordships, my Lord, in terms of section 154(1), my Lord, there has to, if commission of a cognizable offence comes out from the facts of the case, there has to be a registration of FIR by the police.
This doesn't divert filing of CR case. Where is that? Does it say?
Lordships, it says, my Lord, every information relating to the commission of a cognizable offence.
If given orally, and if not given orally, then?
If not given orally, or if it's not given in writing, Lordships, that complaint can, my Lord.
It means if it is not given orally, that no complaint can be filed.
Straight away, Lordships, in a cognizable offence without the investigation of the police officer, the powers of the magistrate, my Lord, under CRPC cannot be invoked, my Lord.
Where is that?
Lordships,
This provision doesn't say so.
Clear. Provision, my Lord, explicitly doesn't state, my Lord.
Yes.
If
So
I may,
you just make it clear before the court.
Lordships,
The court is not satisfied with your submission.
Lordships, my Lord, I will satisfy, my Lord.
Yes.
Now, Lordships, in order to completely understand, Lordships, the reason being that there has to be a police, my Lord, there has to be a police case first and an investigation carried out first by the police authorities, is because, Lordships, my Lord, in various matters, what had happened is, Lordships, that through the magistrate, Lordships, criminal proceedings were initiated against, my Lord, even bank officers, even, my Lord, in commercial transactions. Therefore, Lordships, it was through interpreting, Lordships, section 154(1) and subsection 1 and 3, the Honorable Apex Court in this judgment, my Lord, the judgment which I had cited,
Where is that?
had come to the
Has the book come? No, but then, Master, it's not there in the library. How can it be? Oh, you did not? Should have 6 SCC. 287. Yes, 2015 6 SCC. Volume 6, yes, 6 SCC means volume 6. Yes, Mr. Go ahead. Please, the book has not arrived. Book will be coming. Yes.
No problem, Lordships. I will just read out the, if Lordship permits me, my Lord, I will read out the operating portion, my Lord.
Okay, read out.
Lordships, in our considered opinion, a stage has come in this country where section 156(3) CRPC applications are to be supported by an affidavit duly sworn by the applicant who seeks the invocation of jurisdiction of the magistrate. That apart, in appropriate case, the learned magistrate would be well advised to verify the truth and also can verify the veracity of the allegations. This affidavit can make the applicant more responsible. We are compelled to say so. As such kind of applications are being filed in a routine manner without taking any responsibility whatsoever, only to harass certain persons. That apart, it becomes more disturbing and alarming when one tries to pick up people who are passing orders upon a statutory provision which can be challenged under the framework of said Act or under Article 226 of the Constitution of India. But it cannot be done it cannot be done to take undue advantage in a criminal court as if somebody is determined to settle the scores. Now, Lordships, this is the operative portion, my Lord. We have already indicated that there has to be prior applications under section 154(1) and section 154(3) while filing a petition under section 156(3). Both the aspects should be clearly spelled out in the application and necessary documents to that effect shall be filed.
That comes in the case of, refusal of registration of FIR. If you refer to 154(3),
Lordships.
So then, which way? This decision is not at all applicable. Yes,
My lord,
we can issue notice,
this
nothing
is a
beyond that.
my lord, if I may most respectfully submit, my lord, there has to be an FIR first. In a cognizable offence, there has to be an FIR first. Only thereafter, my lord.
It doesn't say where it is laid down. The
Lordships,
episode also did not say it in specific terms. It is here interpreted.
Lordships, no, not my interpretation, my lord. In section 154.1, my lord, and section 154.3, Lordships, it has to be invoked first, my lord, before registration of a complaint case, my lord, by the by the learned magistrate, my lord.
Which was the part of your judgment in 2015 6 SCC?
Lordships, it's
Paragraph?
It's paragraph, Lordships, in my, this is 27, my lord, in my considered opinion.
Yes.
Lordships, that is SCC, my lord. Mine one is, Lordships, Supreme today. It may not match, my lord. But
You have referred to
Lordships
SCC just
will,
now. You have referred to SCC just now.
yes, my lord. I have referred to SCC, my lord, because Lordships, that Supreme today citation, the Supreme today citation which I am holding, my lord, it may not be there, my lord, in the.
Heard, Mr. So-and-so. Yes, Mr. Gurung, you are appear for?
Lord,
My lord, I am appearing for
Lordships,
response on the state.
Yes.
My lord, I want to just make a small reply to that.
Yes.
My lord, basically, when the magistrate cognizes, before taking cognizance under 204, the 204 does not mandate the magistrate to explicitly or elaborately state the grounds.
No, that is understood, but then argument is not on that part. 204 mandates that court should say that there is sufficient reason for proceeding.
Opinion.
That is what. And the law says that it is not required the detailed order should be passed. There is also. But then there has to be indication. Now the argument is not made on this.
My lord,
Argument made by the counsel for the petitioner hearing is that if allegation is for cognizable offence, in such a case, filing of FIR is mandatory.
my lord,
Now, if you do not file an FIR, you can file an FCC.
204
That is
itself
what.
is very clear.
That is so.
Someone in a
Anyway,
warrant case,
prima facie, it's okay. We'll just issue notice. We'll just see.
private respondent.
Yes. Issue notice returnable in.
Lordships,
Sir.
it's fixed in November, my lord. We
We'll-
will take steps, my lord.
Yes.
Within 3 days.
We'll give
But
returnable
Lordships-
days. See, after 2 weeks, this matter will come up again. Okay, so it will be in October. So don't. So just.
But Lordships will just direct one thing, my lord. Lordships will just direct one thing. Let the records be there before Lordships.
No.
Because once the records are,
No.
once the records are,
We'll not call for the
once the
records.
records are there,
Not required.
No. We'll not call for records. Yes.
Lordships, once, my lord,
So-and-so.
if I may
Yes,
just
it's all
say,
right.
my lord,
We have
my
heard you.
just-
We have heard you. We have given you time. We have heard you. We have placed your point. It's all right. Heard Mr. So-and-so. Issue notice. Returnable in 2 weeks. I get 2 weeks. You are for Mr.
Respondent number 1, the state respondent.
ठीक
R. Gurung appears for respondent number 1. And as such, no formal notice is called for in respect of the said respondent. However, petitioner shall take steps for service of notice upon respondent number 2 within 2 days. List matter after 2 weeks.
Deeply open.
Yes.
Lordships will consider my interim prayer on the next date, my lord. Only that
Let us
much.
see. Let them appear. We'll just see.
Item number 2.
Lordships will kindly direct that part, my lord.
That will be open for you to challenge it. So, all right, court has passed on. You can. Yes. Yes, sir.
Your Lordship, I'm entering appearance on behalf of respondent number 1. Your Lordship, is not.
What matter is this?
Restoration petition, Lordship.
Restoration or condonation?
Restoration.
This is condonation first, then restoration.
Yes.
You cannot come to restoration without condonation. 897 days. You'll be filing your objection
Your
or?
Lordship.
Okay. MS Vishwakarma, what Vishwakarma? I just forgot. I forget names. Let me just give you this. APS enters appearance on behalf of respondent number 1 and makes a prayer for grant of. You file an objection, isn't it?
Your Lordship.
How long will it take?
2 weeks' time, Your Lordship.
Grant of 2 week times for filing an objection in the matter. Prayer allowed. List after 2 weeks. This is in Miss Case 181. Huh? That is the one. This is the one.
Much appreciated.
Item number 3, hearing.
Lordship will recollect on the last date. Lordship had raised a issue to the petitioner's counsel whether the matter still remains.
What is the matter about?
Advertisement.
Oh, achha, that by association.
Association.
Yes,
And Lordship had raised queries. And this short time to come with a clarification whether the matter has become infructuous. That is the issue.
May it please your Lordship.
Yes.
Lordship, I'm praying for some accommodation in this matter because we've tried to obtain instructions, Lordship.
No, you have not received.
Lordship, as to the number of members in the advertising association as well, Lordship, we're supposed to bring
It's all right. How?
clarification. 2 weeks, Lordship.
Miss MS so and so appearing for the petitioner. You have no objection, Mr. Khan?
No, Lordship, no objection. Absolutely.
I think if the petitioner submits that the instruction which was required to be obtained as per the order dated 11/9/2023 has not been received by her. Stop. She prays for grant of some more time for the same. Mr. K. Khan, Rana DIG, has no objection. List this matter after 2 weeks.
Grateful, Lordship.
Item number 7.
Yes, Mr. Nag.
Please, Your Lordship.
Yes.
Lordship,
Was it hard before?
yes, Lordship, you have heard to a certain.
By this court?
No,
Or
my Lord. It is not hard.
there appears to be some noting not by this court.
No, my Lord.
It was heard by some other court.
Even this court
Earlier
has,
heard by court number 3, my lord.
even this court has heard something, Lordship.
Yes, with regard to subject matter.
Anyways, Lordship. Please, Your Lordship.
Yes.
Lordship, the petitioner has been appointed on compassionate ground way back in the year
One of you.
1994.
One of you can go. One of you can go. One second, Mr. Nokla. Yes.
She has been appointed as per Annexure 1, type copy, page 11, Lordship. May I read, Lordship?
Yes.
O number 63, dated 16 June 1994, subject to discharge without notice and assigning any reason thereon, Shrimati Degres Basayamot, daughter of late I. Basayamot, ex-LDA, PCCF's office, who died in harness, is hereby appointed to the post of LDA on compassionate ground in scale pay of such and such, plus other allowances, as admissible in the OO, the Divisional Forest Officer, East Kashmir District, Shillong, with effect from the date of joining. Vice Srimati MC Soons, LDA, promoted to the post of UDA. The appointment is purely temporary and subject to government approval and good police support. So since then, Lordship, she has been appointed and she has been serving till date in same post, Lordship. In spite of several representations made to the office concerned, her representation has not been considered, and she is serving in the same post.
Her representation with regard to what? She filed a representation for what? Praying for what?
For promotion or for some beneficial benefits, Lordship, financial benefits, in lieu of her service, Lordship. Lordship, she is bound to come to this honorable court. And another thing is that even her colleagues who were appointed on compassionate ground, much later after her, they have been promoted to the post of UDA, Lordship, who were appointed on the same grounds, Lordship. And
as per the rules, when you become entitled for consideration for promotion?
After 10 years, Lordship.
Where is that rule? You have a rule?
Sorry, Lordship.
That has to be the base of your case.
In the affidavit, Lordship, is there? In their affidavit, I think they have mentioned that.
They have brought in the rules.
I have not brought the rules.
Whether they have brought into the records the rules.
Yes.
Rule has been the entire set of the rule guiding promotion has been appended.
No, my lord, that has not been
No,
appended.
that is required. Without that, I will do it, and that is your duty. If you want this court to accept your submission, then you have to place the related rules before the court. You are guided by what rule?
But it's in their affidavit is there, Lordship. But
No, they say they have not brought in this thing. What this is also, Mr.
No, it was not included in the affidavit.
No. Is in your affidavit is there the rule.
No, in the affidavit, rule has not been enclosed.
That is what
That is
what
what
we
I'm
need.
saying.
We need to see the entire set of rules. That is the main thing.
okay.
You will not be basing on rules.
He has to base it on rules.
Yes, Lordship. That's true, Lordship.
Let him also. You will not be basing on rules.
One Lordship, I have one citation which is passed by the Honorable Supreme Court, Lordship. That is in AIR 1990, SC 164, paragraph 4, Lordship.
What does it say?
It says.
What does it say?
It says like this, Lordship. It is once an incumbent is appointed to a post according to rule, his seniority has to be counted from the date of his appointment and not from
That's
the
no
date.
dispute. We have not come to that question. See, by assuming that you have joined in 1994, when do you become entitled for consideration for promotion? That is the first thing to be determined. What is the basis of promotion? Whether it is merit cum seniority, senior cum merit. Those are where those will be vital factors for considering your prayer which you make. Apart from the fact which you say that somebody appointed after you
Right.
has been promoted.
Lordship,
Come, but then the others have been promoted on what basis? You see, if you see there are certain departments, there are rules are there. There are provisions for fast track promotions. So that is also one thing. By holding limited departmental examination. Now we do not know until and unless you place the rule before us. We will not know.
Lordship, then will produce the rule, Lordship.
You have to, without this court will be handicapped.
Right, Lordship. On the next date, Lordship will bring the rule.
It's up to you, but then if you want to base, say, supposing now your submission is that after 10 years you become entitled. On what basis you say?
On the statement of the.
So is it only, this is the only way, say, now if you had to be promoted to the post of UDA, see, like what would guide the promotion for UDA? Is it qualification based? Is it based on certain length of experience?
Lordship.
There are many things to be considered.
That's true, Lordship. In
We
that
just
case,
cannot go simply by the fact that somebody junior to me has been promoted before. There may be a promotion that junior has higher qualification than me.
Lordship, in that case, on the next day, Lordship, maybe I can satisfy.
That will be better
But
to satisfy the court.
But one submission, very simple submission, Lordship. Up till there, Lordship, she has not been getting any benefit, financial benefit.
You have not even conferred the benefit of SCR, what is that, SCPS
Lordship.
and all?
Nothing, Lordship.
My lord, what had happened is that, my lord, the compassionate appointment, my lord, which the petitioner is relying on, my lord. This is against all norms, my lord.
How? Why?
My lord, the authority, my lord, compassionate appointment, there is a process. There is a procedure.
What is the
has to be
procedure?
approval of the government.
What is the? Is this the approval of the government?
No,
now
this
you
is
have
not
taken
with the approval, my lord.
Then what else?
Most importantly, my lord, it has to be, you have to file, there is a particular format, my lord, in standard format you have to file an application. Now this application will have to be, through the department, has to be forwarded to the government, my lord. Then thereafter the government will take a decision, and only after approval is granted, my lord, then only
What
then.
happened to the case of the petitioners?
The petitioner, my lord, what happened is that, my lord, we kindly see what is the petitioner's appointment.
Just tell me. Just since we are not having the set of
Petitioner was
rules.
appointed, my lord, petitioner was appointed by a person, by an authority who is not entitled to give such an appointment, my lord.
Yes. Then why you have retained her then?
My lord, that is there. The government is retained.
See, your assumption, your silence speaks for everything.
No, my
Do
lord,
not take that stand right now that you have not approved the appointment.
This
The
is-
appointment letter says that she has been appointed to compassionate crowd, and the fact remains on the day of the appointment, there was a
No, my lord,
scheme for compassionate appointment prevailing. See the appointment order. This is-
Kindly what the appointment letter says. my
Yes.
lord. If I am allowed to read.
Yes.
My lord,
please.
the appointment order is issued by the PCCF.
See the contents of the thing.
Yes, my lord. Subject to discharge without notice.
Yes. Then
And
go,
assigning
proceed.
any reason thereon, so and so, petitioner Srimati Disgage Basaimat, daughter of so and so, office, LDA of PCCF office, who died in harness, is hereby appointed to the post of LDA on compassionate ground in the scale of PO 7 class.
That is enough. Once you say compassionate appointment, if you interpret this letter, we'll take that interpretation which favors the petitioner.
My lord, kindly see.
We'll
what
not
the-
go by the other part where you say it is temporary and subject to these things.
Kindly
Subject
what
to approval.
Yes,
Now,
ma'am.
if you do not approve somebody, and if you that person,
My lord, if
there,
my lord, my respectful argument is that, my lord, if there is a process in which a certain thing is to be done,
where is that process?
yes, my lord.
You want to say the principal chief conservator of forest is no authority in making appointment?
No, he's not. That is the case, my lord. And all the other incumbents. my lord,
Who is the authority to make appointment?
it is the government, my lord. It has to
The
be
government is a-
through the
government-
personnel, my lord, personnel and administrative reforms department, finance department.
That is
They are the
for
approving
approval.
authority.
That is for approval. But then
Yes,
if it comes to issuance of appointment or
My lord, I'll take my lord to the scheme, my lord. What it says.
the scheme says that appointment order has to be issued by the thing, personal department.
My lord, it is the scheme.
What is the give? Give a copy of the scheme.
It's 1984. But I am having only one copy at the moment, my lord. My lord, here what it says. If I am allowed to read, my lord, I'll give a copy to. Otherwise, this honourable court may go.
You
through.
have only one copy.
My lord.
What is the
because
way
my-
of coming to court? You are so negligent.
My lord,
This is
because
something
this-
not really appreciated.
Lordship.
You take things for granted.
My lord, that is not the case. But my lord,
How come you have come here? You are using something. There's
lord,
your
my
arm and ammunition,
apologies.
and you do not have a.
my lord, my apologies. It
is something
It should
not-
be there, my lord. But this is the. My lord, kindly goes through the scheme, my lord. It is very clear. My lord, to whom it applies? Number one, my lord. Who can avail and what is the process? My lord, everything is given.
No, you do not have any dispute with regard to the eligibility. Do you have any dispute that the petitioner was entitled, otherwise entitled, for compassionate appointment? Do you dispute that?
They have not challenged that.
That we have not disputed, of course.
See, their appointment order says in compassionate order. Now, if the government has any problem, now government cannot come and contend at this stage that the person have no authority to appoint. From 1994, somebody is going to complete about 30 years of service.
Right.
And this appointment has not been
Her
approved.
service was regular.
Is it
gonna challenge
something
that.
a kind of thing like you do not allow?
How?
See, you allow an appointment to continue for more than 2 decades without approval. This is how.
Lordship, regarding the 10 years prior, Lordship, in their affidavit, it is stated, page 4 in their affidavit. Therefore, the petitioner's promotion or MSCP will be considered as and when the same is due as per rules and norms, that is 10 years of her regular service.
That is what they say. That is what they say.
That's what they say, Lordship.
There is a contradiction. Please come with the rules. We do not want that there remains some obstacle so far as your claim for consideration is concerned.
All right, Lordship, will do
See,
that.
you try to understand that, say, supposing if you want the court to pass certain orders in your favor, so you must project a case that there is no embargo in the act or the rule guiding promotion against you. See, there should not be a bar. That is so. That is what we want to issue.
Lordship, only in the year 2016, after a gap of 20 years or so, they have regularized her, Lordship.
Lord, her service was regularized in the year 2016 only, my lord.
She was appointed in
And my
94
lord,
and then
You
in
have
2016.
not raised any grievance with regard to
Our
that.
stand, my lord.
Oh, no, Lordship, we have raised, Lordship.
No, they have not raised, never raised, my lord.
We have raised, Lordship, in this petition. That's why we have come to this honorable court, Lordship.
No, petitioner has approached this honorable
because of
court
that.
only for promotion, my lord.
We have come to this honorable court because of that, Lordship. Her regularization was done
What is your
after
prayer? What is your prayer here?
Yeah, yes, my lord.
my prayer, Lordship. May I just read, Lordship?
Yes, yes.
In para 16,
Give a prayer. What come to your prayer at page 8?
it is in the premises, it is humbly prayed that your Lordship would be graciously pleased to admit this petition, call for the records and issue a rule calling upon the respondent authority to show cause as to why a writ in the nature of mandamus and or an appropriate rule be not issued for directing the respondent authority to cancel the impugned condition of the government dated 22nd March 2016 to count the appointment of the petitioner from the date of approval and further direct to count the service from the date of her appointment, that is 16/6/1994, for the purpose of seniority, benefit, etc. And after the causes being shown and hearing the parties, make the rule absolute. So we are agreed with this, Lordship. She has been, though she has been appointed in 1994, but they have shown as appointed on, regularized on 22nd March 2016.
There is no promotion. There is no prayer for promotion here. In your case,
Yes, my lord.
you have not made any prayer for promotion.
Lordship, to count the service.
That is okay. They will count. They will be counting, but then that the counting service doesn't mean that you will be promoted.
And seniority and other benefits, that means financial benefits, Lordship. She has not been given any financial benefits.
You have left everything on implication without making a direct, clear-cut prayer.
Of course, we have missed that promotion part, Lordship. What it implies, Lordship. If it is counted from the date of her joining, then promotion also will be there, Lordship.
My lord, the rules say that it has to be counted from the date on which the incumbent is regularized, my lord.
She has been regularized after a
This is what the
long
rules
gap
say.
in 2016, while she was appointed in 1994, Lordship. So, according to the citation which I have given, her date of seniority has to be counted from the date of her appointment, Lordship, not from the date of
My lord will
regularization.
kindly see, my lord, there are not a single representation from the petitioner, my lord, which is on record, that the petitioner has pursued her case.
If petitioner files representation, we will consider it.
My lord, what I am saying is that,
If this undertaking, we will pass an order.
no, my lord, that is not the case. What I am saying is that, my lord will kindly see, even the petitioner has never made any attempt. That's not a single attempt by the petitioner, my lord.
That's not a fact, Lordship.
It is a fact, my lord. What is on record? My lord will kindly see what is there on record.
She has submitted representations, Lordship, in connection
Next
with
date I'll come prepared.
You have to come prepared. See, if you come casually, then it becomes difficult.
Lordship, the fact remains that her post is taken now till date, since the year 1994, Lordship.
So, my lord, if the regularization is taken from the year 2016,
You have given the details of the persons who have been promoted,
Right, Lordship.
though junior to you.
But my lord,
We have given Lordship in this
then-
reply.
but my lord will kindly see they have not been arrayed as a party.
He doesn't have any prior against them.
No, look, if it is a question of promotion, my lord, and so
Yes,
according to the petitioner,
he is claiming the similar benefit.
no,
If
my lord,
he confines himself to the seniority, then definitely.
yes, my lord, because this is on the last occasions also, my lord, that has been his argument that he should be considered as the senior most.
Today till now he has not made that argument. We will say it. His argument is still now confined to promotion. He has not claimed seniority over anyone. Okay, first he has to come across that hurdle of promotion, then only he can jump to seniority.
My lord.
So until and unless that has been done, so you do not say anywhere that you are guided by which promotion policy. Nothing. Your petition has nothing. It's silent.
What is there in affidavit, Lordship? After 10 years, she will be promoted, Lordship. That is there, Lordship.
Exactly, my
Only
lord. So if it is 2016, my lord, it will be 2026.
That is what. If you are, that is what. See, like if you are satisfied
But
with that,
Lordship,
then you
she
have
has
to-
been appointed in 94. How can she be regularized in 2016, Lordship? That too, she has not been given any financial benefits so far, Lordship. In lieu of promotion.
And my lord, in the prayer also, my lord, if I may submit, the petitioner has not challenged her regularization, my lord. Per se, she is not challenged, my lord.
This order was issued on 22nd March 2016. A writ petition came only in 2018.
My lord. After a delay of 2 years.
Ali's Lordship, she should have been given the financial benefits such as ACPS.
You have not specifically pleaded all those things.
What is in my prayer? In my prayer,
It's
Lordship.
nothing. It's nothing. A writ petition is very cryptic.
We have basically challenged this order, Lordship. This annexure 2, Lordship, as to why she has been regularized after a gap of so many years.
You have challenged it also after at least
2 years.
waiting for two years.
No, in the
2016,
meantime,
2016 March that order was issued. Well, you filed your writ petition when? Anyway,
2018, my lord.
2018.
there are many
But,
aspects.
Lordship, in between representations were there, Lordship, which we have submitted. Annexure 3, in Annexure 3, Lordship. Yeah, page 14, Lordship.
Well, this is only one representation dated 2017, my lord.
That is in between, Lordship. After that order was passed in 2016, the petitioner has submitted this representation in 2017, Lordship. After it has been rejected, then only we have come to this honorable court.
Well, this is only one representation.
It doesn't. One
How many representation is needed?
My lord, if
For a
petitioner-
department to consider somebody's representation, how many representation is needed?
My lord will kindly see what I am trying to impress upon this honorable court is that, my lord, over all these years there is not a single representation. The moment her service is regularized, my
Over
lord,
all this year, petitioner under impression that she is holding a regular post.
And my lord, even in her prayer, my lord will kindly see, petitioner has not challenged the regularization.
She has
Petitioner has challenged the condition, my lord.
She has challenged. She says that her appointment should be given effect from 1990.
She has challenged the condition, my lord. Condition stated there.
Change the condition.
Lordship,
If you change the condition, she will not have a problem with 2016.
Lordship, after
Regularize it from 1994. If you are ready to challenge that condition, then
Lordship, after they have passed, after the respondent has passed this order on 22nd March 2016, then the petitioner annexed 2, Lordship, page 13. Then the petitioner has submitted her representation in the year of 2017, Lordship. After the
5th December 2017.
Lordship, after
More than 1.5 years. You have submitted your representation on 5th December 2017.
After my representation has been submitted, then only I have come to this honorable court. But Lordship, the fact remains that in spite of all this, no financial benefit has been granted to the petitioner up till date.
The petitioner also not very careful about her rights.
Maybe some lapses are there from her side, that I do admit, Lordship, but
Mr. Bhattacharya, tell us
My lord.
her entry into the service.
My lord.
You say that is not a compassionate appointment
My lord.
done after approval. Then her entry to the service is by what? It doesn't say that is in exercise of power under Regulation 3F. Then what else you have? What other power you have to take somebody in service?
My lord, that
So
of
you
course,
can do whatever you like.
That of course is a.
So for you the law does not apply, isn't it? You can do whatever you want. You take somebody the way you want, you appoint, whether rule permits or no permits, you're not at all bothered.
Mistake has been done, that of course, my lord.
Mistake has been done, it is not only done. Continued for 24 years, 23, 24 years. Okay. So you just cannot make other person suffer also. Once your letter, see, the letter says that basically you have taken her into service on the basis of her claim for compassionate appointment. Why you have appointed her only? Why not at somebody else?
My lord, the compassionate appointments, my lord, have to follow a certain procedure, my lord. On the next date, my lord, I will bring everything before this honorable court, my lord. What is the process? What is the procedure? So, my lord, my respectful submission is that
how did you allow this appointment order to stand for so many years?
how can you challenge that out?
my lord, that is there.
See, you have taken somebody in service. You have mentioned that as compassionate appointment.
My lord, the question that
Now, only thing you are raising right now that this is temporary appointment, and has not been done by following the terms of the policy.
That is the normal.
important question that may arise, my lord, is that if there is a certain laid down procedure, my lord, now can there be a break in such procedure, my lord? My lord, as far as compassionate appointments are concerned, my lord, if it is to be done in a certain manner, my lord, now can it be done?
Your silence basically waves of that.
After 29 years.
Your officer has issued an order appointing somebody on compassionate ground, and you just taking the plea that no, we have not approved as per the requirement of the policy. And that also in a substantive post. It is not that you have taken somebody in this thing. Somebody was promoted to the post of UDA. By that reason, the post held by that person as LDA was lying vacant and then taken the service of the petitioner there. In a regular vacancy. By conferring a regular scale. You retain somebody in service. If petitioner remains mom, then you will have no problem. You will just allow her to remain in same post. Only thing is that you do not want to confer her any benefit. That is your attitude, nothing else.
My lord, in her affidavit, we
If
have.
she had not come before this court, you would not have raised all those things.
No, my lord will kindly
You would
see.
be happy that she is remaining there and she is not asking for
No,
promotion.
my lord will
She
kindly
is not,
see. My lord will kindly see the petitioner has approached this honorable court only after the regularization letter. It's not a case, my lord, where the petitioner has approached.
Definitely, the petitioner was otherwise probably under impression that she is regularized from 1994.
Because otherwise, my lord, she could have approached the authorities.
This
or even-
regularization came on what basis? Was it on the basis of her request or by is a regulation work by the department? The proposal for appointment compensation ground in respect of so where is the proposal? You come to your annexure 1, page 10, your affidavit of opposition.
In inviting a reference to the proposal cited above, I am directed to inform you that the proposal for appointment on compassionate ground in respect of Srimati Douglas Basaimer, daughter of so and so, LDA as LDA on the condition that the date of effect of such appointment should be from
See,
the
there is a
date of-
reference, if you see the reference, the thing, there is a reference of letter dated 11/2/2015.
My lord, MF.
Where is that?
MF.
When this thing came?
MF.
Let us see whether that has been done on the request of the petitioner or not. If you see that has been done on the basis of the request of the petitioner, then petitioner will not have a case.
Well, that is, of course, my lord, I have to admit it's not enclosed in this affidavit.
You try to find out what is the letter about.
My lord.
We would also like to see if there is a proposal. The proposal is pending from how long? If it is a case that proposal was made then and there or just after taking into her service, and if you slip over it, then you are responsible for it. You cannot blame petitioner for that. Anyway, you please come with the rules.
Lordship.
There is a rule holding the area.
My lord.
What is that rule?
But this is employment on compassionate ground of the son and daughter near relatives.
No, it's a rules guiding promotion and all. That is your speaking of a policy of 1984, isn't it?
Yes, my lord.
This is no more. That has been discontinued in
Yes, my
2009
lord,
or 10.
2010, man.
Anyway, just come with some extra copies.
My lord.
And then what about the rules guiding promotion?
Promotion, my lord. I'll also try to get it.
Is there any reference of that related rule here? The
Well, that-
entitlement of a person
Lordship,
That
or ACPS and then
look at the rule, Lordship. Let him produce, Lordship. He's better person.
I do not know whoever produces it. This is not a problem. See, like the court wants to see.
petitioner should make an endeavor also,
The
my
thing
lord.
is that you are the petitioner.
My lord.
If you make a claim, it's up to you. We cannot force them to produce something to improve your case. And this
My lord,
rules will be
NH
available. The rule will always be in public domain. It is not a confidential document, so there should not be any problem for you to obtain.
ACPS is enclosed, my lord, in our affidavit, which is at annexure 2, my lord.
ACPS would come if a person is not considered for promotion, isn't it?
My lord. So this ACP is included, my lord.
So when shall I keep it?
Or it may come up after 2 weeks, my lord.
3 weeks, Lordship.
You want more time, longer time?
My lord, we have, and in our affidavit, my lord, we have also enclosed, my lord, the rules from the Personal Administrative Reforms B Department Shillong, my lord, which is at Annexure 3.
In your affidavit?
My lord, it comprises of the, my lord, district selection.
How many affidavits are there in this case?
My lord, 3, because...
1, 2, including 1, 2, 3, 4, 5, 6 affidavits filed already.
My lord, we have filed 3, my lord. 2 additional affidavits, 1 affidavit.
Why so many affidavits?
My lord, what had happened, my lord, in the course of the hearing, my lord, there were certain queries which had fallen from this honorable court, my lord. So we had to clarify that, my lord. That is exactly why we had to file the affidavit.
The order passed by this court?
No, my lord, the earlier courts.
And to each affidavit we have filed a reply, Lordship.
It's okay, but then it only, see, like increases the volume of the file.
No, my lord, in page 22 of that, the first affidavit, my lord, the annexure 8.1, this is rule 8.1 is there. My lord, 9.1 is seniority. So that we have relied, my lord.
Your affidavit, the main affidavit?
Main affidavit.
Which you are referring to?
My lord, page 22, the running page 22, referring to 8.1, my lord, temporary / ad hoc appointments.
No, what is this? This is a part of what? This is
a part of, this
temporary
is
ad hoc appointment.
This is annexure 3, my lord. This is supporting our stand, my lord. Direct recruitments to various posts falling within the purview of the district selection committee are to be made only with prior consultation with the respective district selection committee as soon as vacancies occur. If any district selection committee is not in a position to do so, if may be necessary in the exigencies of public interest to resort to, this is showing the temporary appointment of the petitioner, resort to temporary appointments or appointments on ad hoc basis for which prior approval of the cabinet with the views of Personnel and Administrative Reforms B Department should be obtained before proceeding with such recruitment as per instruction contained in this department OM dated 3/10/87. The officers appointing authorities are therefore required to have all posts filled up in a regular manner through the district selection committee and not to allow the persons appointing temporarily on or appointed on ad hoc basis to continue beyond a period of 2 months.
So which way it helps you?
My lord, we are stating
beyond the period
that
of 2 months.
my lord,
Now 24 years and 2 months you are equating.
my lord, that is there. But here we have dealt with seniority also, my lord. What determines the seniority?
Anyway, this I do not know which way this provision has any application to.
No, my lord, next date I'll try to get all the relevant rules. The petitioner, my lord, has been sleeping over her rights for all these years.
This is a part of SCPS.
Yes, my lord.
Now your clause 3 says at page 12, annexure 2, casual workers, including those with temporary status of or those conferred with regular casual workers,
Shall not be eligible, my lord.
Yes. Well, what about the compulsion? Your appointment letter is
Because,
very.
my lord, our stand.
This is the compassionate appointment, or
My
it
lord,
is.
our stand is that, my lord, if my lord kindly.
No,
allows
if
me-
compassionate appointment is to come after approval,
My lord.
and if any appointment is made before the approval,
My lord, if
what
I'm allowed
happens to
to,
that?
my lord, if I'm allowed to refer to page 3, para 6 of my affidavit, my lord, affidavit in opposition.
yes.
That in response to the averments made in para 3 of the writ petition, the answering deponent states that the then PCCF, on witnessing the plight of the petitioner and her siblings on sudden loss of their mother, therefore gave immediate appointment purely on temporary basis and subject to government approval and good police report. The appointment so given was not in accordance with the scheme for compassionate appointment.
It's all right. But then it makes sure that you are aware of the appointment. And you say that this thing appointing authority by witnessing the plight of the petitioner and her siblings on the sudden loss of their mother, therefore gave immediate appointment. That shows that is on compassion.
But, my lord, here
You
we
are
are
not
referring to the annexure.
You are rather this averment will help his case. Will help petitioner's case. Anyway, Mr. Nogla would definitely like to see the laws holding the arena of promotion.
Lordship.
Before you go by your submission that after 10 years is considered for SCPS. But then if your claim is for promotion,
Lordship, the fact remains that she was appointed to many years
that's
back.
just for the timing, let us forget it. We will
She
come
was
to that
recognized in
controversy and
2016.
say supposing assume that you are appointed on, by assuming that you are appointed on 1994. Then also,
She was
that
appointed.
when you should become eligible for promotion.
That is after 10 years of the Lordship.
My lord will
10 years for promotion or SCPS?
ACP. My lord. We did not say promotion.
From the date of appointment, Lordship.
Talking about the
ACP, my lord.
perhaps you are not getting the query of the court.
My lord will kindly.
Query is that your entitlement for becoming this thing, for receiving benefit under SCPS is one thing, and the entitlement for consideration for promotion is different thing.
Yes, my lord.
Right now, this court is interested to know that after how many years of qualifying service you can be considered for promotion to the next higher rank of UTC. How many years?
Lordship, I'll bring the rule.
But my lord,
If you say that your prayer is for this thing, for the seniority and for promotions, then in such a case you have to tell the court.
my lord will kindly see, my lord, if I am allowed to submit. My lord, the petitioner has neither prayed for ACP or MACP benefits, my lord, in her prayer in the writ petition.
So you can.
But that will come automatically,
That
Lordship.
means that they are asking for service benefits. So if you say service benefits, it will include everything.
And my lord,
Automatic, it has
para
been
15,
included, Lordship.
para 15 of our affidavit, my lord, annexure of the same annexure 2, my lord. There we have, it is very clearly stated, my lord, who are entitled to financial obligations.
Page
My lord, page 15.
of whose affidavit?
My lord, of our affidavit, my lord, state affidavit. Page 15, my lord.
Yes.
There shall be two financial, my lord, para 1.
Yes.
There shall be two financial obligations under the scheme, counted from the direct entry of a government employee into regular service, my lord. So the term is very clear, my
This is
lord.
still clear, but then subsequently that has been modified. Now MSCP
My lord,
is
later on MACP came, my lord.
yes. So once MSCP comes, then 1224 goes. It is
My lord,
1020.
ACP will be considered for earlier appointments, my lord. Future appointments, MACP will come into existence, my lord.
It depends upon from which date MSCP has been made applicable.
If I remember, my lord, it's
Tell me what
2011.
is to be said.
2011.
Anyway, that comes later. That question comes later. Any? Aspect for say on the joint prayer made by the parties. This is matter after. You want it after 3 weeks?
2 weeks also will do.
After. We'll take back your thing. You just place it on the neck of it. Yes.
Item number 10.
Nokma, appointment of Nokma.
My lord, not appointment of Nokma, my lord. It's a Balpakra matter, the compensation matter, my lord. My lord, in this matter, my lord, today I must seek my lord's indulgence just for 1 week, my lord. We were required to file the affidavit.
This court will accommodate.
Oh, my lord, I deeply obliged, my lord. It's,
Probably there was an incident in my house yesterday.
My lord.
And it still has a bearing on my thing.
My lord.
I've not been able to concentrate properly.
My lord.
It was me who first noticed it.
Oh.
And
Yes,
it was really horrifying.
Yes.
I grew up in a tough way. Okay, but then this is something I've never expected also.
My lord, yes.
So yesterday was a terrible day for me. Today also I'm having that
my lord.
terrible effect of that terrifying.
Lord. Yes.
Anyway, you have any objection?
No, I have no objection.
When do you want it? Oh, that is a matter which you said that issues to cover this thing. That is basically it's to determined by judicial.
By the judgment of the single judge.
And his case is that there are some executive communication which gives him a fresh cause of action.
My lord, that's the case. My lord, after a week, my lord, we'll file it in the post and we'll serve a copy to them. And maybe after.
Now, what you will find?
Your lordships had required them to file an affidavit to bring on record one certificate and one agreement.
So, my lord.
There is no, there is further 2 weeks time for production of documents as required by this court or so and so.
On 27th.
Does it say that it has to be by way of affidavit?
It was understood because there are previous orders, my lord.
Yes. Okay. We'll just say that Mr. P. You have been praised for and granted 1 week more time for complied with the requirement posed by this court orders dated 27/6/2023.
My lord. My lord. I am deeply obliged.
List accordingly.
Highly obliged.
Deeply obliged. Yes.
Noted. Noted.
VC.
Yes, the court is over.
I'm sorry, my lord.